Good morning. Welcome to our second top tips of 2025. My name is Ger Connolly. I'm delighted to be joined by my colleague, Ronnie Neville. And today's topic is to discuss the future of work. I think all of us will agree that COVID-19 fundamentally changed how we work. Remote working was perhaps for a chosen few, but now 8 out of 10 roles could potentially be done remotely. It also had a huge impact on our use of technology. And it's estimated that 5 years of technological advancement happened in only 12 months. All that has created a huge change in what the future looks like, in particular the use of AI. But balanced against that is the EU's current ambition that we still would be transparent in relation to equality and inclusion, gender balance, and other things such as pay. Ronnie and myself are going to discuss these topics this morning. And thereafter, during our talk itself, if you want to insert some questions in the Q&A box below, we'll try to answer them at the end. So hopefully we'll have 10 minutes at the end or slightly longer to discuss the various things that we have discussed. I'm going to hand over to Ronnie, who's going to take you through his part of the presentation, and thereafter it'll be myself. Thank you.
Thanks, Ger, and good morning, everyone. We've got quite a lot to get through, so I'm going to jump straight in relation to some important and relevant features of AI. If you're like me, you've probably attended a couple of sessions on AI or AI in the workplace already. Personally, I find it a bit daunting, but for reasons I'm going to explain, there's no more hiding whether you're legal or you're HR. And if you are using AI in the workplace, as most employers now are, there's some important provisions coming down the tracks that we need to take on board. There's already legislation in being. You might not know about it. In the EU AI Act of 2024, it's already AI in the workplace is very prevalent for most employers across different aspects of employment, and it's going to become even more significant in the context of important changes from August of next year. That's why we're including it as part of the top tips, because you've got a year lead-in time to prepare for what are essentially very significant changes coming down the tracks for any businesses, small or large, who are using AI in the workplace and need to get to grips with their incoming significant obligations in respect of the use of AI as deployers or users. Where are we seeing AI currently within the workplace in HR? It's across the gambit. It starts at recruitment. There's AI tools for use in performance management. There's AI tools in the context of learning and development and benefits plans, comp and bens in health and safety. There's AI tools, which you've probably heard about, in the context of monitoring and surveillance and very strict rules and the overlap between AI, use of AI, and GDPR and data privacy. And there's AI tools even now in the context of termination. And I just picked a couple of examples for cases that are hitting the headlines in relation to the use and misuse or abuse of AI from a workers' and employee rights perspective. The Amazon case, would you believe it goes back to 2014, and the Amazon case referred to a tool for automated hiring of roles, and the relevant software for hiring of roles was shown after even 1 year to have disproportionately favoured male candidates over female candidates. Our HR person or marketing person always refers to the use of our marketing intel, garbage in, garbage out. It's the same for AI in the context of the data that gets input, and the use of algorithms is what churns out the results. And it was clear that the software engineers were predominantly male, inputting the relevant criteria for the hiring of certain technical roles, which meant that there was disproportionately favouring or disfavouring female candidates. Another example, that's for recruitment. Even on termination, Estée Lauder got into trouble in the last couple of years in the use of an AI tool used for screening and interviewing in redundancy processes. And in the context of redundancy, you folks will know it's all about process, it's all about fairness, and it's all about transparency in the context of consultation. And the problem with the use of AI in this particular scenario was that there was, it was churning out results by reference to the algorithms used, but no one could determine the basis upon which the relevant folks who were chosen for redundancy were actually selected. So there's no transparency, and that clearly causes problems in the context of fairness, which we are also used to. In the context of employment law, where are we seeing the pinch points for AI? And by the way, this isn't a negative AI session. This is a session to look at where there's potential risks and upcoming obligations from next year. But AI is fabulous. The use of AI and the savings and where it's possible to use automation, the savings, the efficiencies are very significant. But there are these very significant obligations coming in next year. Where are we already seeing the pinch points? There is an obvious existing mutual obligation of trust and confidence. It's trust and confidence which flows both ways. The trust and confidence that the employer has to have in the employee is that their work product is genuine and is safe for authorized use, is their work product. So again, look at things with students and with employees who are using AI, ChatGPT and the like to deliver work product which isn't theirs. That could be a breach of the trust and confidence. But equally, there's a mutual trust and confidence from the employer's perspective to fairly and transparently and reasonably use AI in the context of how AI is used by the employer in terms of the relationship of employer, whether it's monitoring or evaluating for performance, etc. And often we see the pinch point in terms of even the couple of cases I mentioned for Estee Lauder and for the Workday or for the Amazon case, in the context of pinch points where folks are being negatively or adversely prejudiced in the context of the 9 protected grounds. So whether it's in relation to gender or favouring racial profiling or favouring certain grounds over others. So that's where issues can arise separate to the data protection issues. When you're looking at AI, there are certain AI that under the legislation, the existing 2024 Act, that is just specifically already prohibited. So when it relates to emotional interference, AI systems in the workplace or biometric categorization, that's just prohibited. It just can't be used. The high risk AI is where HR becomes relevant because these categorizations of high risk AI are all featured in HR, whether it's recruitment, performance management, decision-making affecting terms of work, promotion or termination, or allocation of tasks based on behavior or personal traits. Any automated or AI functions in use in the HR systems at the moment, from next year, there's going to be specific and onerous obligations on employers who are users and deployers under this new legislation because they are going to be using high-risk AI. What are those obligations? Big difference between providers, who are the companies, and deployers. But beware, many of the larger employers who are attending this session or generally will tweak and modify specific AI software technologies that they're using, platforms, etc. And depending on the manner in which it's tweaked or modified for use, they could slip from being a deployer where there's certain specific obligations into being providers. So you need to take note of that. What are the deployer obligations? From next year, significant obligations with sanctions, criminal sanctions, and very significant fines for misusing or abusing AI in the workplace from August 2026. And those obligations include using the system in accordance with the instructions. Someone has to be assigned or delegated a function of overseeing the AI system. They have to be trained and competent and have the support and authority they need. I talked about garbage in, garbage out. Whoever is using and monitoring and overseeing the use of AI has to ensure that the data that's input, which generates the results, is relevant and sufficiently representative. And they need to monitor the system according to the instructions, and they need to be flagging incidents or pinch points or concerns in relation to AI to the providers so that it can be improved and corrected, and also to keep logs generated by the system. So what are the top tips then on AI? Quick check on the time, already a minute or two over. Risk assessment. First of all, carry out a risk assessment. You've got a year lead in time. What AI are you currently using? What is the risk categorization? Is it prohibited or is it high risk? What are the obligations that flow from that? If it's high risk, I've gone through what those obligations are and the types of high risk. Almost all of HR general functionality and functions, if you're using AI, will come into the high risk category. And then the best top tip is do a stress test. Before you start implementing the AI, run tests, test sessions to ascertain what I call a stress test to see where it lies. Compliance, incorporate your systems in advance, make it part of your governance. As I said, there's significant obligations and penalties that can flow from misuse or abuse. Draft an accessible use policy for use of AI. That's twofold. The acceptable use will explain in a transparent way how the employer is going to use the AI, but also the acceptable use for AI in the workplace needs to explain to employees what's acceptable use and what's not acceptable use in the context of the work that the employee is performing and the degree to which employees are using AI in the delivery of work product. And then training is crucial, not just for the individual who's going to have a specific role as I've identified, but also for training for staff generally. Next, looking at trends in flexible working. The most significant legislative provisions for flexible working include the Work-Life Balance and Facilities Provisions Act. The folks on this call, on this video presentation in HR will know about some of the high-profile cases that have already come before the WRC or the Labour Court. There have been a couple of notable ones. There is a very useful, relevant, and significant in the context of how the employer conducts itself code of practice. It's what I'm calling the Bible for how employers conduct themselves for flexible and remote working. It's not legally binding, but what I'm saying is, like many codes, woe betide the employer who doesn't follow the code, because it's an easy out for the WRC who says you haven't followed the code of practice and you should have. So it does have persuasive effect. What's the difference then between flexible working and remote working? Well, flexible is where the employee's working hours or patterns are adjusted, whether it's through remote working, flexible schedules, or reduced hours. It's for any employee who has a child under 12 or a child under 16 if they've got a disability. And it also covers flexible working arrangements. A request can be made if someone doesn't have a child of 12 or 16 with a disability, but someone who's providing personal care to a prescribed person. It's a various categories of individuals that are prescribed and where the person is in need of significant care or support for a serious medical condition. If you are an employee meeting those criteria, you're eligible to make a request for flexible work. Remote working is everyone who has 6 months can make a request for remote working. So it's not as prescriptive or limited as flexible work. And remote work, then what is it? It's where the employee can carry out their duties at a location other than the employer's place of work without a change to their hours or to their work or duties. The reason why we're going to focus on remote work is because that is the area which we're seeing from a relevant and from a practical perspective that's coming before the WRC and that's most frequently causing an issue. It's most frequently requested. Remote work forms part of flexible work, but remote work in particular is what we're seeing a lot of, and requests for remote work. What does it mean, this new legislation? You follow the code, it's a right to request it. It's not an automatic right to get it. So the right to request it, it's subject to conditions. The code is really useful. It sets out the reasons that might ground a request. It talks about what suitability is in the context of being able to frame your request and for the employer to be able to determine whether the remote working arrangement is suitable in the context of where you're going to be working from. And the request has to be sent as soon as reasonably practicable, not less than 8 weeks before the requested date. When it comes to decision making, it's all about the process, and it's all about following, what I'm saying is following the code. So you look at the employer's needs, the employee's needs, and the requirements of the code. The decision has to be objective, fair, and reasonable. The code sets out the type of questions that can be considered, When the request can't be granted, it sets out what alternative arrangements should be considered and potentially offered, and it sets out the timeframes under which the process should be performed. It also explains the process that should be followed when you're accepting a request for remote working and the process that should be followed when you're refusing a request for remote working. The code also sets out what happens when the employer decides that there are reasons why it's not working anymore. I now need to, having approved remote working, I now need to end remote working and the reasons that might justify that. And it also sets out the basis for an employee making a request to the employer to end remote working. And it also talks about the potential to end remote working if in the case of abuse. Doesn't talk about what abuse is, but if you follow the same mantra of having regard to the employer's needs, the employee's needs, and follow the prescribed and recommended provisions for making decisions on remote working under the code, that will keep you honest in the context of any claims that there's been a breach of the legislation. You've probably heard about this TikTok case. I'm just setting out a few of the examples of the cases where remote working requests have come before the WRC, and it's the same theme that's flowing for all of these cases, which is follow the process, a right to request, not a right to have it guaranteed. In this case, the employer's requirement for a return to work and the request not to return to work was refused. They argued that in-person presence, the employer argued that in-person presence was crucial for team engagement, collaboration, knowledge sharing and training. It's the usual explanation offered by most employers who are insisting on a return to work. The WRC said the request was refused following an objective, fair, reasonable decision-making process, which looked at the needs of the employee, but also looked at the needs of the employer. The HR team met with the employee on several occasions, discussed the request, looked at a variety of factors, and also looked at the employer's business plans and needs. And this is the magic bit in terms of what is probably the theme for all of these requests that are going to come before the WRC, that the complainant's view that the job could be done remotely doesn't take precedence over the employer's evidence-based view that the employee's return to the office results in increased productivity and accuracy. Ultimately, it's within the respondent's remit to decide what's best for the business. And the WRC couldn't evaluate the merits of the refusal. It couldn't step into the shoes of the employer to decide, was this the right decision taken or not? All the WRC can do and did do in this case was to decide if the process was fairly followed. Similarly, in this Taylor case for microchip technology, where the request wasn't submitted in accordance with the legislation, and that's why the WRC decided the request was misconceived. But look at the negative publicity and the negative findings that can happen when the process isn't followed. Even though the case was misconceived, in this case, the adjudication officer was critical of the employer because there was a corporate policy recommending or endorsing hybrid working, but they didn't have a policy that set out how those applications have been made and how the decision should be followed. So it's a perfect case to show that you might actually defend the case, but the negative publicity from any AO decision or WRC decision, which effectively says that the employer has to have a policy in place which sets out how the code is going to be followed and how any request is going to be made. And in this case, this was a tech services and consultancy company. The client had requirements that the work be performed in situ. The complainant made a request, had caring needs for their daughter, and made a request that they should be facilitated in return in being able to work remotely, and it was rejected. And again, the WRC held that the employer did all that was required of the employer in looking at, consulting with the client. Can you make exceptions? No. Consult with the employee. Are there any alternative arrangements can be made? No. Rejected by the employee. And once the employer goes through the process in respect of the request for remote working, the fact that the remote working request is denied does not give rise to a case against or a positive case against the employer. So what are the takeaways? It's a right to work request and nothing more. Once the employer acts in an objective, fair and reasonable way, there's considerable discretion for the employer to reject any request that's been made, and the WRC doesn't have jurisdiction effectively to review the merits of the refusal. and there's strict record keeping requirements. Finally, touching on age and retirement age, and a significant change that's likely to come into play next in the next year or two in respect of a bill that's relevant for all of our employers. The benefits of multi-generational workplace are well established. Synergy, a large pool of talent, enhanced innovation. Many of our clients will talk about a dearth of talent and difficulties in attracting and retaining talent. If you've got an older workforce, it behoves a modern employer not to simply apply a retirement age willy-nilly, and instead to look at the benefits of having a multi-generational workforce, and the stats are there to back it up. That said, if you do have an occupation, a company retirement age, Ireland was the outlier for many years in having, under the Employment Equality Acts, a lawful basis to apply a company retirement age, and didn't have the rider under the Framework Directive that said it had to be objectively justified by a reasonable aim and the means are appropriate and necessary. That hole has been plugged. Ireland is still a bit of an outlier because you can have a retirement age, but now that the burden is on the employer to make sure that there's a lawful justification in applying that retirement age. There's a bill currently going before the Dáil, which is going to allow an employee to make a request of the employer to not be retired at 65 if that is the age, or if your company retirement age is retired at 60 or retired at 65. The state pension age has now gone to 66. This legislation is going to allow an employee to say, I would like to stay on till 66. And it requires the employer to look at that request and to consider it fairly. And if rejecting the request, to allow someone to stay on till 66, because that's the pinch point. That's what caused a lot of requests from employees who are being retired at 65, who are going to be stuck financially because the state pension was increased to 66. This legislation essentially does no more than what we as a team in Mason Hayes, we've got 32 lawyers in the employment team who are constantly telling our clients, since retirement age became such a significant issue in the context of the change in the law with the objective justification requirements, what we've been saying to clients is incorporate an evaluation of your company retirement age and update it regularly, and look at this code of practice, the code of practice for longer working. If you're going to hold the line on a company retirement age, look at the code of practice and determine whether it's still fit for purpose, whether it's the SLT or the board looks at whether it's, again, move away from 65 if you can, probably move to 66. But if you're holding the line at 66 and retiring people from 66, why are you doing it? Is there a reason that you want to maintain intergenerational fairness, motivation, dynamism, health and safety, succession planning? If that is your rationale, document it and make sure that you've got a notes taken to show that when the case is made, probably prima facie case is going to be made that it's discriminatory on age grounds. At least you've got some basis to show that it's objectively justified by a reasonable aim. Mallon is a big case that people need to know about, because it's a case that went to the Supreme Court saying that the employer doesn't have to look at each specific individual scenario to determine whether it's objectively justified. If the company as a whole has decided that there are reasons underpinning maintaining and applying a company retirement age, then it doesn't have to look at the individual scenario. And that was of significant relief to employers, because it meant that they didn't have to, for each individual person who was affected by the company retirement age, to look at their circumstance and decide, does this intergenerational fairness, succession planning, or health and safety apply to the individual? The sting in the tail, however, from the subsequent cases is that in Mallon's scenario, the sting in the tail for it has to be proportionate and reasonable is that Mr. Mallon had other income stream coming in. And in other cases, whether it's Ferrero or in Ronan versus in Garda Síochána, now they're under appeal, but even though it's objectively justified and they're still applying Mallon, the courts are still looking at whether it is proportionate and reasonable for the individual concerned. So there's a bit of confusion when you're applying your retirement age as to whether you can step back and say, we don't have to look at the individual, we can apply the retirement age. We've got our notes, we've looked at it from a board perspective, and you don't have to look at the individual. Or you have to say, okay, from a company perspective, it's objectively justified. But now we need to look at the person who's aggrieved about being retired out and look at whether it's disproportionate by reference to their specific personal circumstances. That's why, when it comes to top tips, there is considerable confusion remaining about whether you can, as an employer, safely apply a company retirement age. It looks like it's a bit of a cop-out and saying come to the lawyers and get legal advice, but it's a real watch this space, because some of these cases are still under appeal, and that's why we're saying, from a practical top tips perspective, look at your age. What is it? What's the basis for maintaining it? Is it 65 or 66? Are you going to get ahead of the new law coming in and move it to 66? And if you're going to hold the line on 66, what's your objective justification? And if you are going to retire someone out at 66, it wouldn't be a bad idea to contact her or myself, or one of our colleagues, because we'll be able to tell you what the mood music is or what the developments are by reference to these cases that are currently under appeal. Over to you, Ger.
Thanks, Ronnie. We're now going to look at the evolving expectations around DEI, ESG, and CSRD, and just all the acronyms themselves can be quite confusing. It's become an interesting topic simply because perhaps there's a misunderstanding of what's happening in the US. But DEI is diversity, equality, and inclusion, and that has been in existence for well over 40 years. ESG is probably a more recent phenomenon, and the employment aspect of it is to do with social. And then we have probably something new, which again, driven by the EU, which is CSRD, which again concentrates more on the larger enterprises as opposed to small SMEs. There is a misunderstanding in that perhaps Ireland and the US, and certainly Europe and the US, there is a fundamental difference about what was deemed as affirmative action in the US. And affirmative action was very much driven by the use of quotas to effectively balance workforce in terms of equality and inclusion. And one of the first things of these executive orders was the banning of affirmative action. And now private sectors in the US don't have to comply with these anymore. And what they see is a merit-based selection of candidates in its workforce. And positive action was a much lesser thing that existed and has existed in Ireland. And it allows an employer the opportunity or the ability to take positive action to support a disadvantaged ground. But it's not compulsory. So the distinction between the Ireland and US model was, in the US up until recently, it was, if you want to call it, enforced compulsory, while Ireland, it was much more optional. There will be, I think this year, there will be two changes in relation to, if you want to call it, positive action. And one in particular is of interest. There is lots of bills at the moment, and unfortunately, they seem to have the same name each and every time, or it's quite difficult to distinguish them. But the general scheme of the Equality Miscellaneous Bill 2024, which is published in January, it is proposing to increase the ability of an employer to create positive action by looking at things that prevent disadvantaged people entering the workforce. And not only can you have positive action, as in favor one part of your workforce over the other, where you believe it's helping a disadvantaged background, this can also be done on selection. But I think one of the more interesting changes, which is in the Employment Miscellaneous Bill 2025, and this got published just last month, is that the Employment Equality Act obviously outlaws discrimination or prohibits discrimination on 9 grounds. And those 9 grounds have been more or less set for the last 27 years. But there is now a proposal that a 10th ground is going to be added, and it's going to be called the economic social disadvantage. And economic social disadvantage will be where a person is suffering discrimination on one or more of the following grounds. And it's to do with poverty, sources of income, level of education, address, type of housing, employment status, social and regional accent, and from other similar circumstances. And this would be quite a fundamental thing for us to change by adding in a new ground. The bill is at a very early stage. It's currently before the second stage of the Shannon and have to come back. But it is more than likely that a new ground will be added, which will be social economic disadvantage at some stage, perhaps towards the latter part of the year. We just might move to the next slide. Gender pay gap reporting. I think we've all become quite familiar with gender pay gap reporting. But gender pay gap reporting now applies to entities that are 50 or more. So the threshold has reduced from 250 people, employees, down to 50 employees. And gender pay gap reporting, it probably has oversold itself. It's the mean average of the difference between male and female. You pick a point of time in in June of any given year, as there's the snapshot, and you do an analysis of the average hourly wage of male versus female, but as a block. So the average of the totality of male versus the totality of females. And that is reported on an annualized basis. The changes that are being introduced now is that, firstly, the deadline for reporting has slightly moved. It used to be December, and I think there was concern that a lot of the gender pay gap reporting came out when the news cycle was slow, and now it's moved forward into November. But more importantly, while previously it was you had to put it up on your website, there is now going to be a new online portal that's going to be a collective. So you will you can and you should continue to put it up on your website, but you will also have to make it available on the new portal, which is going to come live, and the portal is going to be a much more searchable thing. So I suppose the key takeaways for this is that for those who have already been subject to gender pay gap reporting, the deadline is slightly moved and you need to comply with the portal. But for those who are experiencing it for the first time, I think you need to be aware of these. Another, what has proven to be quite a controversial change is that statutory sick leave obviously came in after COVID, and it was a progressive scale. It was going to go from 3 days to 5 days to 7 days to 10 days over a series of time. But at the start of, or the end of last year, the government conducted a review of whether, in blunt terms, employers can continue to afford statutory sick pay. And while it doesn't affect maybe perhaps lots of large employers, for small employers with inflationary demands and just the general cost of doing business, the feedback was that increasing statutory sick pay, which is set at €110 per day, from 5 to 7, the economic conditions was not prevalent for doing so. So quite controversially, the government has paused it for now. So statutory sick pay will remain at 5 and not increase to 7 days. It's important to note it's paused as opposed to, and I'm sure it's going to have to be reenacted. ESG, the ESG is such a wide-ranging topic, and the topics are so large, they're actually called pillars underneath the various sections. But one of the interesting things, and again, both Ronnie and I are concentrating on employment aspects of these, is that to do with a social pillar. And the Health and Safety Authority has, quite interestingly, in this program for work in 2025, has indicated that it's going to carry out 11,000 inspections this year, which, when you think of it, it's a mammoth amount of inspections that they're going to do. But in relation to this, one of the things that they're going to concentrate on or place particular emphasis is all called psychosocial health, which is to do with workplace, remote working, flexible working. It should always be remembered that code of practices in relation to bullying, they were developed by the Health and Safety Authority. We always assume that the Health and Safety Authority is always going to concentrate on building sites, farms, but at 11,000 inspections per year, and particularly if you're looking at things like psychosocial health, it is going to be increasingly common for, I'm going to call it, more private sector companies to be inspected by the Health and Safety Authority. And I think it's going to be interesting to watch out this space, in particular in relation to the types of inspection that are being carried out and what precisely are they reviewing. The CSRD reporting requirements, I suppose the benefit in relation to this is that it is to do with very large listed companies, and the directive itself is again an EU directive that came into effect last year, and it will concentrate on from the 1st of January 2025. And there's requirements report in two aspects, which is your material aspects, financial aspects in relation to how climate is affecting your business. And the second aspect is how you are trying to improve your climate footprint. But the interesting part of this is that there is an obligation on the employer that it shall engage with the employee representative before publishing its report. So we're now seeing this concept creep into, particularly through EU directive, in that EU directives, that there is more employee engagement in relation to these topics. And employee representatives, it is quite, sometimes they can be very easily to be identified, where you're members of a trade union or various other things. But trade union activity has decreased certainly in the last 20 years. But employee representatives to engage in topics will now going to probably be an aspect that employers are going to have to get used to, and that where the employees themselves elect representatives to engage in these topics. And effectively, this is a kind of a quasi-vetting of, is the employer and the employee in agreement with the reporting lines? But as I said, this is probably affects very few. It will be for listed companies as opposed to large companies. But there is, the EU has suggested that this requirement might be extended to companies that have 1,000 or more employees. So that will bring within its ambit a lot more companies that currently are covered by it. And the gender balance on boards. So like a lot of EU directives, unfortunately, Ireland can be quite slow in relation to implement it. And the deadline for transposing this directive actually passed on the 28th of December last year. But the reason we failed to implement it is that there was no government at the time. It was just after the general election. And again, this is aimed at listed companies. But the idea behind it is that there would be and member states for now have an option A and an option B. And option A is that members of and it's deliberately called unrepresented sex, but I think in 90% of cases, it is females are the unrepresented sex, would hold at least 40% of the executive positions on a board. And option two is that the government or each member state can elect to add in, if you want to call it a second criteria, that at least 33% of all directors or executive directors would be of the underrepresented sex. It's interesting when you look at statistics, why are quotas necessary? Quotas are necessary because they're effective. In the UK and Norway, who already had these quotas, they've achieved what they believe is the 40%, and they did so 3 years before their designated kind of target date. But for now, it is that 40% would be female in non-executive. The current percentage is about 22%, and in terms of an executive, it's currently as low as 14 or 15%. The aim is that this will be achieved, or this will be implemented in June 2026. There was a bill, and it was called the Irish Corporate Governance Gender Balance Bill 2021, which was proposed by the last government, but the bill fell away when the Dáil got dissolved last year. But the bill itself has been restored and has come back onto the statute books on the 1st of May 2025. So it is likely that this bill could travel through and then become binding. It's interesting that the bill itself, as of today, that the position would be, it will be the mandatory position that 40% of your board not your executive, would be female versus male, or male versus female, depending on the makeup of the board already, but that the government so far has not elected to go with the second of the, if you want to call it, enforced criteria or the enforced quota. The Act itself does allow effectively positive discrimination, where you have two candidates which are viewed as the same, and the underrepresented candidate should, in theory, win unless there exists exceptional circumstances. And the exceptional circumstances that is being referenced is that there's some other diversity ground not related to gender, which is driving the difference between the two individuals. As I said, the enforcement, the penalties have yet to be set out in the legislation. What the penalties are given a kind of indication is that with all equality legislation, there must be penal and dissuasive, but the extent and scope will have to be set out in the legislation. You will have to put this onto your website, and you will have to report it to a designated body. I'm not sure what the designated body is, again, because of the primary draft of the legislation, but one would assume that if the portal for gender pay gap reporting, you would see that this could be a very easy add-on to something that already exists. The EU Pay Transparency Directive, I think personally, this will probably be the most significant piece of legislation or directive that may go through in the coming weeks, or coming months. We are 1 year off when this directive is meant to be enforced, and the directive has an enforcement date of the 7th of June 2026. And unlike other directives, the government seems to actually be getting out ahead and trying to implement certain parts of this. And while gender pay gap reporting looked at, if you want to call it, male versus female in a kind of pillars, or where they're banded together, the Pay Transparency Directive is going to do exactly the opposite, is that it is going to look at categories of workers. So the important thing that all companies will have to do is effectively identify categories of workers. And you're going to have to show or display what is the difference between a male and a female in that category of workers. So if you were taking a law firm as an example that's built off the concept of junior solicitor, senior solicitor, and partners, in theory, you have categories already built in, and you will have to show the difference of why one gets paid more than the other. Where this reporting is done, and it identifies that there is more than a 5% gap between the categories of employees, and the category can't be justified by what's called gender neutral factors. A thing called a joint pay assessment needs to be undertaken. And a joint pay assessment is actually a combine between, again, employee representatives and the employer, a look at, or an audit of, how is there a gap between the two genders, what's being done to address the gap, and what measures are going to be taken to monitor the pay in relation to this. And it'll be the first time that organizations will have to do such granular look at the various categories of their employees. It also introduces that you must have pay transparency in job advertisements. So a person is entitled to know what is the range of salary that is applicable to that job. And it also prohibits that you cannot ask a candidate what their previous salary or what their current salary is. There is certain exemptions that where for secrecy, or not for secrecy, but for disclosure reasons, where you have only, for example, one person in that category, and by comparing the two categories, it will identify the person. You are permitted to, if you want to call it, withhold that information, but that information will ultimately have to be given to the WRC if the person brings a claim for equal pay. In relation to the right of pay information, an employee now it will be permitted to ask or request from the employee what is their pay progression within their organization. So not only will you be able to ask, how am I compared to my counterpart in the category that I fall into, but you will be able to ask questions such as, what is my future pay level and what is my pay progression? And you're ultimately, when this all boils down to, you will be able to bring a claim if you believe that you're not being treated in a fair and or be discriminated against, that you could be able to bring a claim to the workplace relations where you can effectively seek equal pay for doing like work. And one of the things that has always been quite a controversial topic is that how do you look at people, or how do you value people who are doing the same work or work of equal value? And again, it is hoped that the department, when they're issuing or when they're enacting the directive, they will give much more detail, a code of practice on how you evaluate like work or work of equal value. It will also bring about some fundamental changes to how claims work in the WRC. These are equal pay claims. An equal pay claim, traditionally, it was for the employee to prove that they have been the subject matter of unfair or discriminatory treatment on the grounds of pay. However, that's not going to shift, that it's going to be for the employer to prove and justify the differential in pay, which is not linked to anything to do with one of the discriminatory grounds, in particular to do with gender. The employee should, or insofar as possible, try to identify a comparable employee, but it openly accepts that a hypothetical, as in an employee that could have been paid differently, will be permitted. The scheme, the government seems very committed to this, in that the general scheme of the Equality Bill 2024, which is at the end stage of the Dáil process, it is going to introduce effectively the ban on asking employees about their previous salaries, and also probably before the directive is required to be implemented later this year, that you will have to advertise or disclose salary levels as part of job advertisements. As of yet, we don't know what the penalties are in relation to pay discrimination. As of today, the Employment Equality Act sets that it can be an order enforcing the equalization of pay, and equally it also references that it's a cap of 2 years' money. But in the directive itself, it is suggesting that the compensation will be much wider for an employee, and it would include things like recovery of all back pay, compensation for lost opportunity, interest, and interestingly, it says that there should be no upper limit on the level of compensation. Our top tip for this is that this is a directive that is certainly was 1 year out. The government, of all of its directives on pay transparency, is very much proactive. 2 of the provisions could be actually implemented in the coming weeks, as opposed to even, let alone the next year. But I think it will be important for organizations that start having to think about what are the categories of your employees, if they're not already in categories. And one would have to also suggest that you start actually doing the exercises of comparing males versus females, because a joint assessment, which would be done through the employer and employee, will be time consuming, and the justification of the pay difference will take a considerable amount of time. And again, it will be published on your website, so this information will become quite known, and salary bands and how you deal with pay progression. And it's expected, whether it's true or not, that there will be an increase in the amount of claims for equal pay once the directive becomes fully in effect. That's the end of the various topics that Ronnie and I have covered. We have 10 minutes for questions, and I suppose we'll start with the Ronnie, a question in particular for you. Are you seeing many employers terminate employees for breach of hybrid working policy? And if so, how is the WRC dealing with these cases?
Thanks, Chair. We haven't seen cases from the WRC, but we have, amongst the team, had issues around conflict arising in the context of hybrid working. So it goes back to, what I touched on in the talk in relation to the right to request remote working. And obviously hybrid working is where you're remote working and coming to the office 3-2-2-3, 4-1, the push to come back, return to office. All of this has been widely discussed in the media, and it is becoming an issue that we're advising on regularly, where an employer decides that for business needs, there's concerns in relation to how the remote working is working out. Typical lawyer answer will say that the nature of how the agreement is reached at the outset will be useful for the employer. If you're backtracking, we always want, as an employer, or the legal advisors, say HR, who are supporting the employer, we always want the employer to have made it clear that whatever accommodation effectively that's being afforded the employee in terms of remote working is documented, number one, but also that it's documented that this is something that the employer is offering whilst retaining its discretion to review the position. Some folks refer to it as having a kind of a probationary period to see how it's working out, or just simply saying that it remains subject to review or subject to discontinuing the arrangement. Now, obviously, in the context of a request that's been made, a formal request under the legislation, there may not have been a request preceding the remote working arrangements that are in being, because many folks have kind of retained remote working and hybrid working post-COVID. But in the event that an employer has explained verbally, but preferably in writing, that the remote working arrangements or the hybrid working arrangements are subject to business needs, and then an employee makes a request because they're dissatisfied with the employer's insistence that the hybrid working arrangements are either get amended or are discontinued, then they've got a right to request remote working, which could incorporate hybrid working. And the employer, as per the cases we've gone through, is legally obliged to follow the process prescribed under the law, with that very helpful use of the code to ensure that they are doing what they're required to do. But importantly, all they're required to do is to consider it fairly, reasonably, decide yea or nay. So in the event of hybrid working that's not working for an employer, or if it's being abused, then the normal disciplinary process takes course, normal investigation, and potentially disciplinary sanction in the context of misconduct. I go back to having it written, documented in writing in relation to what the arrangements are. Ideally, again, typical lawyer or typical HR, we would prefer to have a policy in place that sets out the do's and don'ts. It's easier, obviously, for the employer to take issue with an employee and potentially discipline an employee when they're saying to the employee, there it is in black and white, there are the rules of engagement in relation to hybrid working, and we believe that you've fallen outside those rules of engagement, carried an investigation or potentially discipline on foot of it.
Okay. Remote working is very popular in terms of questions, Ronnie, but I suppose another one which probably would affect a lot of people is, if someone makes a flexible working request for carers' duties, what proof can an employer require or can it request?
I think we'd have to be careful about talking about the specific obligation, rights of the employee under the flexible working, the remote working. legislation and the separate obligations on the employer in relation to carers. So what we focused on in this section is the right to request flexible working and remote working. The flexible working obviously involves categories of employees who have a right to request it by reference to either a disabled child of up to 16, or if they're caring for a prescribed person, and that is someone who is suffering from a serious medical condition. And in the separate to the carers leave requirements, which I'd have to look at to ensure that there aren't separate proofs essentially that the employer is entitled to procure from an employee in the context of a request. But in the context of a request purely under the flexible working legislation, then the employer is entitled to consider a request by reference to at least some evidence that the person is a prescribed person as defined. I just gave examples of what a prescribed person is, and they are, where someone is suffering from a serious medical condition and they have to fall within one of the defined prescribed persons. Usually it's a family member or someone who's cohabiting in a civil partnership or other. But again, the code, once the code is followed and the legislation is followed in the context of how the request is made and how the employer has to review the relevant proofs before making the decision. If it's denied, there's no problem as long as they dot their I's and cross their T's in relation to how they've given consideration to the request.
Flexible and remote working is by far the most popular questions we're receiving today, but fortunately or unfortunately, some of them are extremely technical and specific, so we can't get to them. But in relation to just some other of the topics we covered, when is the new obligation of when you're not allowed to ask about previous or current salary going to be effective? And the answer is it could come shortly. It's not going to be in the pay transparency. It looks like the government is fast forwarding it. It's in a bill, and the bill may be, obviously we have started the summer, and the summer will dictate, but I would assume that it will be this year that when that will arise. There's quite a number of questions about the use of the portal and for pay transparencies, and there's obviously the portal is not operational, and questions of what's going to happen if it's not operational. Well, the default position will always be that it should be on your website, and one would assume that the government is anxious to get the portal up because it will allow people search, and it will streamline what is the entire thing. In relation to the pay transparency, there is a question about what about public sector organizations where pay scales are historic and awarded on length of service rather than seniority? I think one of the things that the public service or sector has been extremely good at is pay transparency is very good in the public sector, because you can log on to majority of websites and you can see the, if you want to call it, incremental progressions that happen on a yearly basis in relation to that. I suppose the Pay Transparency Act will try to impose to a certain extent those sort of guidelines onto the private sector where it's never existed before. But I think it'll have probably a more profound effect within the private sector as opposed to the public sector where those information is already available. Unfortunately, we've run out of time in relation to answering other questions. For those who have asked us questions, if we have your details, we will contact you afterwards. Finally, just the three quick things. I'd like to thank Ronnie for his time and participating today, and I think we're all very interested in how AI is going to interact in our day-to-day working, and hopefully we have given you some insight into the directives and particularly the government policy on transparency and inclusion that is still there and hasn't gone away. The second thing is that after this, everyone will be given a Survey Monkey, and I would encourage as many people as possible to fill it out. And in particular, the topics that you would like to have discussed. We will be having another top tips, and the topics that we choose are actually driven by you, the audience, of what you would like to hear from and what top tips as opposed to get bogged down in law, but what top tips that you would like us to cover. Finally, I'd like to thank everyone for logging in today. I hope you found it beneficial, and we look forward to seeing you again. Thank you.